Okay, so as Professor Norman Martinez mentioned, and I'm going to use his words, his description, this is a particular regime, right, of evaluation of liability, which I very much like that expression, and this is the topic of my today's presentation. But this is a master class, so we're going to do some introduction as well to the basic topics, and this is our roadmap for today. So first of all, we're going to look into the international liability regime for the oil pollution damage. I'm going to give you some basics. Then we will move towards limitation of liability under this international regime. And to do that, we will talk about levels of liability and tacit acceptance procedure. We will discuss limitation count, which has to be established under the CLC. We will a little bit talk about willful misconduct and the CLC, but as you've heard, the standard for breaking limitation of liability is exactly the same as under the LLMC, so thank you very much, because my job is much easier right now. We will briefly discuss so-called second and third tier of liability, the funds. We will talk about something which is usually, or maybe not usually, but sometimes omitted when talking about liability for oil pollution damage, these STOPIA and TOPIA contractual arrangements, and I will show you why do we have them. But then we will move towards a totally different example of how the oil pollution liability damage can be tackled. This is under the American approach, and for that I'm going to look into the provisions of the Oil Pollution Act and how limitation of liability under OPA is coped over there. So as we've heard just a second, claims for oil pollution damage are excluded from the LLMC, but this is not to say that the limitation of liability for oil pollution claims is unlimited. Quite to the contrary, it is, and actually limitation of liability, and that's going to be my main argument for today, is a place, or is central, plays a pivotal role for the whole system of limitation of liability. And I'm going to try to explain that. Okay, so this slide is this introduction to the liability regimes for pollution damage that we have in the international framework. We have a separate regime for oil carried on board as cargo, persistent oil, and this liability is based upon as many as 3 conventions today, with CLC being the most popular. I think it has something around 146 members. Then there is the, I call it a sister convention to the CLC, the Fund Convention from 1992. It's slightly less popular. It has 121 contracting states. Last but not least, there is this new recent development, the supplementary fund adopted under the London Protocol from 2003, and this is not that popular. It has been accepted by only 32 states. This does not cover pollution caused by bunker oil in the international framework. We have a separate convention for that, 105 contracting states. Hazardous and noxious, other hazardous and noxious substances are excluded. There is a separate framework for them, but as we've heard, this convention has not yet come into force, although recently there have been some developments in the number of states acceding, so maybe we are looking forward for the HMS to come into force. So going into the oil pollution liability regime, it is based on the idea that the pollution damage may be of a catastrophic character, and the main idea is that putting the liability of on the shoulders of a single ship owner, even coupled with compulsory insurance, is not enough, right? So we need something more. So as early as in the 70s, after infamous Torrey Canyon disaster, they invented this 2-level system of limitation of liability. So on the first level, it is the ship owner and his insurer that are liable for the claims. But if that is enough, and I will later on discuss what are the situations in which the ship owner and insurer will not compensate the victims fully. The victims are not affected because they can go to the second tier of liability. That is this special fund created under the 1992 Fund Convention. This fund is financed by oil receivers. So those who receive oil carried on board as cargo, they pay contribution to the fund. So this fund serves as a, no, I'm looking for the expression in English, piggy box or money box?
Piggy bank.
Piggy bank, piggy bank, for those claims which are not satisfied fully by the ship owner and its insurer, right? Now, what happened at the early 2000s, we had two big catastrophes near European coast, Erika Prestige, and we realized that the monies within the Fund 92 are not enough, and we need third level of liability, and that has been created under the auspices of IMO, a little bit under pressure of European Union, who threatened to create its own regional solutions. So this London Protocol creates the third level of liability. It is so-called supplementary fund, and if the victims are not fully compensated under Fund 1992, which has its own limits, then the supplementary fund steps in. Although, mind you, it has been ratified, this convention has been ratified only by, I think, 32 states so far. So this whole system, as I see it, is based on a specific share of risk between the ship side, being the ship owner and its insurer, and the cargo side, which finance these funds. And the bright line between this division of risk between cargo side and the ship side is, in fact, limitation of liability, because most commonly the Fund 92 will intervene if the ship owner and its insurer calls limitation of liability, and the claims are not fully compensated, and then the victims go to the fund. Okay, so these are three main pillars. At least I like to see, I like to look at the CLC 92 in such a way of the CLC Convention. We have, first of all, strict liability of the ship owner, and that has been something totally new in 1969, but became a common characteristic of IMO liability conventions. And this liability is very strict. It has very limited exclusions of liability, and it's channeled to the ship owner. What does it mean, channel? Any ideas? What do you understand by channeling of liability? Another word for channel is to direct claims. So the claims are channeled, directed to easily identified person, that is the registered ship owner, right? But the CLC 92 does more, because it says claims for pollution damage can be brought only on basis of the CLC against the ship owner, and additionally, there is a long list of parties, including bareboat charter, including managers, whom the parties may not sue for pollution damage. So this is how strict the channeling of liabilities, unless they prove their intent or recklessness with knowledge that the damage will appear. So we know already that that proof is really difficult for the parties, right? Okay. So the second pillar of the CLC is compulsory insurance. The idea is that the ship owner should be reinforced by the insurer, and the claimants have a direct claim against the insurer, and this insurance is attested by a specific certificate given by national administration generally. There are some problems that I will refer to later on related to those certificates being issued to the ship owners on basis of insurance, which is not necessarily up to the requirements of the CLC. We had some examples of that situation. And the insurance is up to the limits of liability. So here again, the limitation of liability is in the center of the CLC framework. Finally, we approach the main subject of our presentation. The ship owner bears that strict liability with the very limited exclusions of liability, but he can limit the liability, right? And this right to limit liability, as we've heard, and we will see that in a second, is very strong. It has been created as virtually unbreakable. But here under CLC, this does not affect the victims because they have the piggy bank. Because they have the piggy bank of the fund and maybe supplementary fund. Right? All right. So the limits of liability as under CLC, as under LLMC, sorry, depend on the ship tonnage. We're not going to look into the numbers. This is not that important. However, I would like to make a brief comment about tacit acceptance procedure. What is that? This is a procedure that has been developed by the IMO in the 70s for some technical changes of many conventions. However, it has become a method also to change the limits of liability, including under CLC and fund convention. So the idea is that we need to speed up and facilitate the amendments to the conventions. So instead of convening a conference with many states, there is a proposal brought by a number of states, and if we don't have a refusal of the proposal by a group of states, and the number is given in the convention, then that amendment comes into force. This is what we call a tacit acceptance procedure, right? So it's in order to speed up the amendments being brought to light, and I believe that in 2000 there was a raise of limits of liability by tacit acceptance procedure. However, there are some problems that the IMO faces. The Secretary mentions the fact that some states have their own internal procedures to ratify the amendments done on the international level via tacit acceptance procedure. So the Secretariat, after many years, receives a note: we ratified the amendment made by tacit acceptance procedure. And the problem is, well, it should have been applied many years ago, right? This is the problem of Poland, for example. It is really difficult to explain to the Ministry of Foreign Affairs that these amendments should not be subject to ratification procedure, right? Because they are against the spirit of tacit acceptance. Okay? Now, limitation fund. Here, the shipowner is obliged to create a limitation fund in a state which has jurisdiction over conventions, and those states are listed in Article 9 of the Convention, and he does it by depositing the sum or producing by bank guarantee or other guarantee. Here, it is clear that the claims may be that the fund may be created before claims are brought. That was not certain under the previous CLC instrument. And the court entertains exclusive jurisdiction over funds distribution. Additionally, the CLC says that the insurer may avail himself of the limits of liability of the shipowner. So this right is granted also to the insurer. As a side note, this phrase was very interestingly interpreted by the Supreme Court in Spain, where, after Prestige, it said that the P&I Hub was not present during the proceedings in the court when they distributed the fund. Therefore, it did not avail himself of the limits of liability because he was not present. And on basis of that, they decided on unlimited liability of the insurer. So that is something that we haven't heard before, that type of interpretation. Now, this fund shall be distributed among the claimants in proportion to the amount of their established claims. And also, this is a kind of incentive mechanism for the ship owner to attract him to take up the prevention measures. Very often at seas, he's the first one who can practically limit the scope of the oil pollution damage. So the CLC says that claims in respect of expenses reasonably incurred made by the owner to prevent or minimize damage shall compete in the fund together with the other claims. So he may make use of the fund as well with regard to that type of claims. Breaking limitation of liability, as we've heard, very, very difficult. This threshold of intent and or recklessness with knowledge, known also in common law doctrine as willful misconduct, is really difficult for the parties. They have to prove that. Additionally, we've heard everything about that. It was, as under LLMC, a kind of a compromise under the CLC 1992. So the industry agreed for the limits to be raised, but on the other hand, they wanted to have that virtually unbreakable right to limit liability. And that's what happened, although we have some examples that this interpretation is not followed in all cases. The same Spanish Supreme Court held the ship owner in Prestige case, held that the ship owner had acted recklessly with knowledge because he should have known about the technical flaws of the ship, and even though he decided to start the voyage in the bad weather conditions. So the question is whether this should have known, the objective test, is something that we are looking for here, right? Maybe it should be objective, not subjective. Okay, so this is a slide talking about Fund 1992. So the second tier, I've mentioned that it is financed by the cargo side, but maybe it's interesting to look when the fund will step in the shoes of the party who has to pay the claims. This one we already covered. We said that generally, in majority of cases, the fund will compensate the victims because the ship owner and the insurer called like limitation of liability. Fund will also be liable if ship owner is exonerated, if those very narrow exemptions have been met, but also the Fund 1992 will pay the victims when they are unpaid fully or at all, because the ship owner is financially incapable of meeting the obligations in full, and financial security does not cover or is insufficient to satisfy the claims for compensation for damage, right? And you may ask, how can it happen? Well, it can. We have some examples of that, and this is a big deal nowadays at the LEG committee in IMO. The thing is that there are no clear guidelines of how the states should act when issuing this certificate. There are some guidelines from 2024, but they are not very precise. And there have been instances when the ship owner presented insurance, usually from so-called non-IG insurers. These are insurers which are not members of the international groups of P&I clubs. And even though the insurance was in place, it turned out that it was not sufficient as requested by the CLC. So this is a situation which again is not difficult for the victims because they have the fund, but it destroys this delicate balance of share of risk between the cargo side and the ship side. The cargo side pays more in that situation. And I believe that they created a working group on the last LEG 111 Canada is the leading country for this working group, and they will develop new guidelines for accepting insurance in order to be able to issue the certificate. However, fund has some exclusions as well. There are listed here. Maybe the most interesting for us would be number 4. That is, for the fund to pay the victims, they have to be able to prove that this oil spill comes from a ship carrying oil as cargo or after such a voyage. This is what the convention says. So in other words, fund will not compensate something as a mystery spill. I mean, understand me correctly, the parties do not have to pinpoint to exact ship, but they have to prove that this is not a bunker oil, or that, for example, this oil does not come from a platform or other facility, right? Now, this there are some cases in which, on basis of that provision, fund has refused to compensate victims, very often state governments who conducted cleanup procedures. However, recent case of, I think, Israel, which shore was damaged by the oil pollution from an unknown source in 2021. The fund decided to cover that claims because it was proved that the pollution could not have come from another source than the tanker. There was no facility, and after examining the pollution, the oil, it was clear that it was not a bunker oil. So in this sense, in these circumstances, the fund intervened and paid the victims. But with the dark fleet, and Lloyd's List estimates that today something around 10% of tankers are in that dark fleet, we may get many more of that type of situations. And again, this is dangerous for this delicate balance, right? Victims will be paid by the fund, but then majority, the burden rests on the cargo side, not the ship side. And Fund 2003, not that popular, although providing much greater limits of liability than Fund 1992. Probably why not that popular? Probably because of that so-called Fund 2003 participation fee, which says if you state are the party to the convention, but you don't have oil receivers that receive 150,000 tons of oil by year, so we cannot make them pay the contribution fee. You, as the country, you will pay participation fee counted on basis of 1 million tons. So it's the state who then pays the fund. That is my impression. That's why this convention is not that popular. And now Stopia and Topia. Okay. And now Stopia and Topia, what are they? So after Fund 2000, Supplementary Fund London Protocol 2003 were introduced, the review showed that the greater burden of compensating the victims rested on the cargo side, not the ship side. So they paid a greater amount of claims for pollution damage. It was something of 64% of claims being paid by the cargo side in comparison with 36 being paid by the ship side. So then at that moment, some states started thinking maybe this is a good idea to revise the oil pollution scheme, maybe by lowering the limit for the threshold for breaking limitation of liability. And now at that situation, the shipping industry came with this voluntary proposal of contractual arrangements, two, one called Stopia, the other Topia. Both of them work similar. There are differences, obviously, but generally they mean that ship owners agree to indemnify, to pay Fund 1992 or a supplementary fund, a proportion of that what they paid to the victims. So as you see, this is a voluntary contractual arrangement which was introduced, but the international scheme in the convention remained the same. Okay, and this is the slide which talks about other distinctive features of the CLC and fund regime, for which we don't have any time at all. But the oil pollution damages which is compensated on basis of the CLC fund covers something what we call pure economic loss. But with the environmental laws is quite restricted, because it says only reasonable measures of reinstatement. That's all what the CLC says. It covers the oil pollution only from seagoing vessel actually carrying oil and during voyages following such carriage, but not structures, not facilities. Only persistent oil carried as cargo, so not bunker oil, and this channeling of liability. And this slide is important for me because later on we will look into OPA. And now that's the moment, that would be a good moment to look at this alternative regime created under national law. United States is not a party to the LLMC nor to the CLC fund regime. It has its own statutes. We start briefly, very briefly, with the Limitation of Liability Act from 1851. So it's a very old legal act, very short, I would say, developed much by the case law, right? It's all in the case law, what the LLA is about. It was adopted in 19th century to provide the same benefits for the American shipowners to make them competitive on the market. And the system is totally different than international framework. The first difference is that the limitation of liability is based on post-casualty value of the vessel and its pending freight. So if the vessel is total loss, the limitation of liability fund may be zero, right? That harsh reality was seen after the Torrey Canyon incident, where the limitation of liability fund was $50. This harsh character was mitigated later on in sometime after 1934. In 1934, there was a big passenger liner catching fire, I believe, and there was more than 130 passengers dead. And after that incident, what they did, they amended LLA, saying that, well, for personal injury claims, the limit of liability will be counted by reference to the tonnage. And today, I believe it's $420 per gross ton of the vessel. But this is not applicable for seagoing vessels. This is applicable only for seagoing vessels, but with the exclusion of pleasure yachts, tugs, cows, barges, right? Now, we quite recently, December 2022, we had another development. Again, after an incident, there was a Conception dive boat catching fire off coast of California. I think something around 30 passengers and crew died over there. And in the aftermath, the Congress adopted so-called Small Passenger Vessel Act. And this Small Passenger Vessel Act excludes from the ambit of limitation of liability small passenger vessels. Right? If you want to know what are small passenger vessels, there is a very complicated definition. We're gonna forget about it for the sake of the lecture, but this is the newest development. Now, who is entitled to limit liability under LLA? The list is much shorter than under LLMC. Shipowner and bareboat charter, it has been expanded a little bit by the case law, which clarifies that it means also shareholders, mortgagees, corporate parent companies. The number of claims, types of claims allowed to be limited is also smaller. There is a long list of claims excluded from the limitation of liability, and I'm not going to go through that in details. Grounds for denying limitation of liability is fault or privity, right? And this is a term which has been expanded greatly by the case law. To cut the long story short, it's much easier to break limitation of liability under LLA than under international conventions, right? Also, because of the burden of proof. While under international conventions, it is the victims who have to prove that there was intent or recklessness with knowledge. Here, it is for the ship owner to prove that there was no privity or knowledge, his privity or knowledge. So what is the future of the LLA? This act has been criticized in the doctrine and in the case law. I believe that in some cases the court said that it is hopelessly archaic or not up to date, but still we have it. There were some attempts. In 2010, I believe the American LLA passed a resolution in favor of the Congress adopting LLMC. After Deepwater Horizon, there was actually a proposal made to repeal LLA, but there was no political power, no political demand to do that, not enough at all. Instead, what we see is those small steps made. The step-by-step approach, I like to call it, to amend slowly the LLA Act after incidents, Morro Castle or Conception. Okay. But we are talking about oil pollution, and with that you can forget about LLA at all, because for the limitation of liability for oil pollution damage, there is a totally different legal act in the United States. Why? Because the United States adopted a comprehensive act dealing with oil pollution liability, criminal and civil. And this also includes specific norms for limitation of liability for pollution claims. And that is why you cannot limit under LLA, but you can limit under OPA. Can you do that in reality? We will see that reality is not that perfect for the responsible person under OPA 90. So to start with, why we talk about a national act and not international convention when talking about United States? Well, United States participated actively in negotiations of the 1984 protocols, but the infamous Exxon Valdez accident happened near the coast of Alaska, causing catastrophic damage, the greatest catastrophic damage, which was later on beaten by Deepwater Horizon, but it created such a public rage might be a bad word, but I guess it could be, yes, it could be used, that the Congress opted, instead of participating in the international regime, it opted for all more strict solutions. And that is what we have, that is OPA, which was so strict that, and I think I said it exactly the same last year, I still remember, it was called by the industry not Oil Pollution Act, but Oil Punishment Act, right? But United States are too big markets to ignore, and therefore those standards were simply met by the industry. So what is so different in OPA in comparison with the CLC? And that is why I wanted you to look into CLC distinctive features, because here this is, everything is quite different. First of all, OPA, I mean, it's a national act, therefore it can be much more comprehensive. It covers cargo oil as well as bunker oil. It covers liability not only from ships, but also from facilities. And that is why OPA was the act governing the pollution from the platform, deep water forestry platform, and this well from which the oil came, right, in the Gulf. It is applicable not only to pollution damage on seas, but also to inland pollution, as long as the pollution occurs in navigable waters. There is no channeling of liability, as we have it under CLC. There is broad environmental damage, not only the cost of reinstatement, but also the cost of so-called lost services that the environment provides for the public can be compensated under the OPA. There is civil and criminal liability, and last but not least, there is a wholly different philosophy concerning limitation of liability under OPA than in the international framework. Why this is a wholly different philosophy? Why do I say that? Well, not only the limits are higher, but specifically the conduct for breaking limitation of liability, for proving unlimited liability, is much easier to obtain by the victims. So the OPA says limitation does not apply if an incident was proximately caused by gross negligence, right? We don't see that at all under LLNC. In fact, the resolution that we've heard clearly states that intent or recklessness with knowledge is much higher than gross negligence. It should not be interpreted as gross negligence. And here gross negligence is, in fact, I believe when they negotiated OPA, the initial proposal was to have negligence, not even gross negligence, right? But later on the Congress amended that proposal. Then we have willful misconduct, and willful misconduct is intent or recklessly with knowledge. And then we have violation of any applicable federal safety, construction, or operating regulation. And I mean, if you think about oil pollution damage, each incident will probably include some violation of some safety standards, right? This harsh term is a little bit mitigated by the fact that this damage has to be proximately caused, so the victims have to prove that actually the oil pollution was proximately caused by breach of that safety or construction norms. But I mean, those grounds for breaking limitation of liability are much wider than in case of LLMC. And on top of that, it is not only, as we have under international regime, personal act or omission of the liable person. Here we have that breaking of limitation of liability may be done by gross negligence, willful misconduct or violation, blah, 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 by responsible party, his agent, employee of the responsible party. So apparently they didn't read that nice comparison with anthropological hand and arms part, but also any person acting pursuant to a contractual relationship with the responsible party. So any other party who is in contract with the responsible party, with the ship owner, bareboat charter. Now, of course, pursuant to can be open to discussion. What does it mean? The OPA says pursuant to and not in connection with the contract. So some people say, well, pursuant to should be interpreted narrower than in connection with. Pursuant to should be interpreted as doing the contract, as contracted, right? But others say pursuant is any activity in connection with the contract concluded by the third party. And actually there is case law supporting the wide interpretation of pursuant to. So we have that enormous difference when you look at the grounds for breaking the limits of liability. Not only that, because there are other ways how the liable party, responsible party may lose limitation of liability when it fails or refuses to report the incident, when it does not cooperate with the authorities in connection with removal activities, and so on. This all makes me to conclude that while under the conventions we may say that limitation of liability is a strong right, under OPA I would say that it is simply a privilege which can be easily lost. Right? This is my impression. And this is the last slide that shows actually what is the difference between breaking the limitation of liability under OPA and under CLC. CLC personal act of the ship owner, and here we have this bunch, this group of people, right, whose acts may lead to loss of limitation of liability. And then in international conventions you have intent or recklessness with the knowledge. Under OPA, gross negligence appears, for example. And with that, I think we are done.